Former Geffen Sotheby CEO and convicted wife killer Jason Rohde was back in the headlines this week. In 2019, the Western Cape High Court found him guilty of murdering his wife Susan at a Stellenbosch hotel in July 2016. Rohde maintained that his wife killed herself after discovering that he was continuing to have an affair. However, the court found him guilty of strangling and smothering his wife to death and then trying to cover it up by staging the murder scene to make it look like she had committed suicide. He was sentenced to an effective 20 years behind bars. This week, the case was in the Supreme Court of Appeal, where Rohde is challenging his conviction and sentence. I'm Karyn Rice, journalist for News 24's Multimedia Department, and this is The Story. This week, we'll revisit the Rohde case, where it's at, and what's likely to happen next.
You're listening to The Story. It's a podcast by News 24. We'll speak to journalists and experts about the week's biggest story. This is what we saw, heard, and uncovered this week.
We're talking to News 24's specialist legal journalist, Karyn Maughan. Karyn, Rohde's been on bail for the past 2 years. This is quite unusual for someone who has already been convicted. Can you tell us why he was granted bail?
I think that there's a direct consequence of the kind of judicial politics in the Western Cape High Court at play here. Judge Guyot Hlophe, was at the heart of various complaints laid by Patricia Goliath, the deputy judge, president of that court, and in which specific allegations about her handling of the Rohde case were raised. Now, pivotal in this case are key forensic disputes and allegations that the judge did not properly apply her mind to the evidence before her and essentially treated Jason Rohde in an unfair way that violated his fair trial rights. The Supreme Court of Appeal did find that there was a basis to consider his appeal, that it may come to a different conclusion having looked at that evidence. And it also found that he did not constitute a flight risk and that Hlophe's refusal to grant him bail in those circumstances was unjustified. Many eyebrows were raised at the time, but it has been a decision now in these last few days. We have seen the court evaluating the evidence before it and making it clear that it is not entirely satisfied that Jason Rohde was, as he claims, wrongly convicted.
The Supreme Court of Appeal heard Rohde's appeal on Monday. Can you explain how it all works? It's not another trial, right? It's an examination of the original trial records.
Exactly. An appeal essentially is an evaluation by a higher court of records, transcripts, and evidence and the judgment ultimately reached by a lower court. So there's no evidence led, there's no testimony. It's simply an evaluation of what is described as the record of the trial that came before. Rohde has raised a number of forensic issues in terms of his appeal. He continues to insist that he did not kill his wife, that there is compelling forensic evidence that proves that she did in fact take her own life. And he has also again raised through his lawyers these allegations that Judge Guyot Hlophe did not properly evaluate that evidence and bring an open mind to that case, and as a result, his fair trial rights were violated.
As you've said, a lot of the case actually hinged on forensic testimony. Can you tell us about some of the differing opinions heard in Rohde's trial?
I think pivotally, when the Supreme Court of Appeal heard this case, and particularly Judge Ian van der Merwe, it did not want to get into the various twists and turns as articulated by Judge Guyot Hlophe in terms of her evaluation of the forensic evidence, which even the state has conceded was in some parts unsubstantiated by the actual forensic evidence at the scene. Crucially, the state conceding that it was not necessarily a sustainable conclusion, for example, that Rohde had smothered his wife. The court also not entirely convinced by the lower court's finding that the smothering and the strangulation had occurred in the context of a violent and protracted altercation. It very much appears that there is, in the mind of the court, evidence that Susanruders was manually asphyxiated. Bruising on the side of her neck, for example, and 250 milliliters of blood that was found in her stomach and intestines. And the court expressing severe reservations about how this could have happened, as the defense suggests, in the context of a fall that occurred the day before, and in the context of her allegedly suffering from nosebleeds. Ian van der Merwe is saying that it was highly unlikely, or suggesting that it was highly unlikely, that a woman like Susanruders would simply swallow so much blood without trying to deal with the nosebleed effectively. So it's clear that the court is not wanting to get into the various disputed aspects of forensic evidence that have defined this trial and that formed much of the defense's attack on Gayet Salih-Hlophe's judgment. They are focusing on what can be proven, and they very much seem to be swayed in the direction that there is clear forensic evidence of manual strangulation in this case.
There was a lot of testimony during the trial about Susanruders' mental state at the time, whether she was depressed and suicidal or merely anxious because her husband refused to leave his mistress. In the defense's heads of argument submitted to the SCA on Monday, they raised the fact that their witness psychiatrist, Larissa Pinheiro-Peter, was not even allowed to complete her evidence. What was some of the evidence around Susanruders' mental state at the time?
Well, Larissa Pinheiro-Peter, of course, she was also involved in the Oscar Pistorius matter, had essentially been brought in to construct a kind of forensic analysis, post-mortem analysis of Susanruders' psyche. And obviously, Judge Gayet Salih-Hlophe was very unhappy about this because she said, she didn't necessarily have direct knowledge of Susanruders' inner life, and that this was an inappropriate witness, and basically stopped her from testifying, which was one of the, as you correctly point out, major grounds raised by the defense. Pinheiro-Peter was, had engaged with various reports and evidence, basically suggesting that Susanruders had been desperately psychiatrically disturbed by the revelations of her husband's affair, that it had done significant damage to her, and that she had displayed possible suicidal tendencies in the wake of that information, which may have culminated in her taking her own life. Of course, Susanruders' own psychologists and counselors have disputed this, and said that, while she was hurt and betrayed, the possibility that she would leave her children, her daughters, by committing suicide was something that was just untenable. And the state in its heads, Louis van Niekerk, saying that she was a deeply courageous woman who, while she was, fighting with her husband, was essentially fighting for her marriage, was fighting to sustain that relationship, and had no intention of taking her life that morning.
Karyn, which way do you think the SCA is leaning, and why?
I strongly believe that the Supreme Court of Appeal will find that Jason Rohde is guilty of Susanruders' murder. They will find that there is clear evidence that he manually asphyxiated her, but they will not make determinations with regards to an alleged beating or attack that occurred prior to her death. I think that the court will also reduce his sentence from 20 years to the minimum sentence for murder in these circumstances, which is, non-premeditated murder, and reduce it to 15 years.
Is that because it's what they may see as a crime of passion?
Well, the law is quite specific. If you're accused of non-premeditated murder or murder under the principle of dolus eventualis, the minimum sentence is 15 years. So typically you don't see courts going over 15 years, just like they don't go over, that it's very unusual for a court to go over a sentence of 15 years for corruption. The only real option for them is to lessen that sentence because there are compelling and substantial circumstances that justify the imposition of a lesser sentence. Of course, with Jason Ruders, lawyers have tried to argue that there are such grounds in this case, and that the court should consider that. And at one point, his lawyer, William King, saying that in circumstances where wasn't specifically referring to Rohde, but where someone had sort of strangled someone in a moment of in a kind of crime of passion scenario, and it had been a brief thing that had happened, the court could look at possible correctional supervision as a sentence. But Judge Ian van der Merwe making it very clear that the court was not even consider that kind of situation or sentence because of the incredible seriousness of this offence.
When do you think we can expect a ruling from the SCA, and do you think it will be possible for Rohde to lodge a further appeal if the verdict is not in his favour?
The Supreme Court of Appeal is it is the most efficient court in the country, so I think we should get the judgment out probably within a month, possibly even as early as 3 weeks. I think that it is very likely that Jason Rohde will bring an application for leave to appeal that ruling in the Constitutional Court, where I expect he will argue that his fair trial rights have been violated. The Constitutional Court, however, does not often get involved in criminal appeals. Oscar Pistorius failed to persuade it to hear his appeal against his conviction by the SCA. But obviously, it remains to be seen what kind of arguments he will raise in the event that the SCA does, in fact, find him guilty of murder.
And Karyn, would he go straight to jail pending that appeal? Would his bail then be revoked?
It would normally be revoked, but if he could bring a legal application to say that he is making an application to the Constitutional Court, and that pending the determination of the court, he should be allowed to remain out on bail, given that he has demonstrated that he is not a flight risk. However, the state may well argue that given that, the chances of him necessarily getting a hearing in the Constitutional Court are not entirely certain, and the seriousness of the potential of the sentence that he faces, that the court should reevaluate and should go ahead with revoking his bail in the circumstances. So he does have legal options here. It will just really be about the approach of the state, and also about the approach of the court in those particular circumstances.
Thank you so much for your time, Karyn. That's all we have time for this week. That was News 24's specialist legal journalist, Karyn Maughan. I'm Catherine Rice, and this week's episode was produced with the help of Alyosha Kolstock.